Mediation and collaborative law are two alternative dispute resolution options that allow you to resolve your differences outside the court system. Both are voluntary processes. Essentially, they give the participants the opportunity to decide the outcome of their case as opposed to potentially leaving the decision-making to a judge. This allows divorcing people to have greater control over how issues are resolved, and this generally leads to less animosity, resentment, and minimizes the potential for future litigation. In the mediation process, the parties hire a neutral third party called a mediator, who is usually a family law attorney, to help the couple work through all issues relating to their divorce. The divorcing couple can work with the mediator on their own, or they can include their attorneys as part of the mediation process. The mediation process is usually less stressful and produces less anxiety than litigated cases because participants feel more in control. If the mediation process is not working, the parties always reserve the right to opt out and to pursue a divorce through the courts. Collaborative law is similar to mediation. It's a process that allows divorcing couples to work with their attorneys and other professionals who have been collaboratively trained to solve issues relating to the dissolution of their marriage. The goal of collaborative law is to work cooperatively and avoid the uncertain outcome of going to court, and most importantly, to achieve a settlement that is mutually acceptable to both divorcing parties. The one major distinction between the collaborative process and mediation is that if the parties agree to opt out of the collaborative law process, they cannot continue to use the same attorneys or professionals that were previously used. In arbitration, the divorcing couple agrees to appoint an arbitrator who will act as a judge for their case. Arbitrations are handled very much like a trial in that the arbitrator serves in the role of the judge. Non-binding arbitration is where the parties pick an arbitrator to hear the matter and make recommendations for settlement. They are recommendations only and non-binding. This differs from mediation in that the arbitrator does not try to massage the settlement, as would a mediator. Binding arbitrations are handled very much like a trial in that the arbitrator serves in the role of the judge and makes the final binding decision from which any appeal is very limited.